Patrick Barry presenting his wonderful paper today. I just want to say a few things because it's a topic fairly dear to my heart. It's a public law topic about ministerial responsibility and oversight, and of course that then raises the issue of the remedies that are available when oversight might be defective. And it's based on our system of responsible government, which you'll all understand, of course, to be based on the Westminster system, where ministers hold the confidence of the lower house of Parliament, and while they do so, they are able to be ministers. But when they don't hold that confidence, then they're not, and that is considered to be the ultimate guarantee of freedom and liberty in our society, and that's why our framers chose not to have a Bill of Rights like the American Constitution did, because in the American Constitution, of course, there is acoustic separation between the executive and the legislature, whereas in our polity, they are effectively one and the same. The people who are the ministers form part of the House of Reps and the Senate. Now, I mentioned the UK, so they have parliamentary sovereignty in the UK, and that basically means that anything passed by the House of Commons, approved by the House of Lords, is unimpeachable by the House of Lords or the Supreme Court. That is what parliamentary sovereignty means in the UK. And that for a long time also extended to government ministers who were acting pursuant to what is known as the royal prerogative. There have been in recent times some inroads into those matters in the UK through the process of devolution of parliamentary sovereignty to the European community. Now, with the passage of the Human Rights Act in the 1990s, the higher courts in England are able to make a declaration that legislation that's been passed, duly passed by the Parliament, is incompatible with the European Convention rights. Now, what does that mean? In Australia, if a court made such a declaration, it would mean that the legislation is invalid. It doesn't mean that in England. It means that Parliament then needs to put matters right. So it doesn't result in a declaration of invalidity, and that's what's called weak judicial review. Contrast that to the US system, and this harkens back to the most seminal case in US constitutional law, which is Marbury and Madison. When the US Supreme Court declares legislation to be invalid, it is invalid, and that's what's called strong judicial review, which is heavily criticised in the academic literature because, of course, it's counter-majoritan, it's anti-democratic in that sense. Now, I won't go into the ins and outs of Marbury, notwithstanding it's a very fascinating case, but I just wanted to pick up where Patrick's going with his talk and just focus on one particular area that came to a head in Australia some time back, but it was a seminal point in our history, and that was the tamper incident that happened in 2001, just before 9/11, and just on the eve of a federal election in our country. Now, the starting point goes back to 1215, the Great Charter that was forced on King John by the English barons included a clause that no free man will have his freedom taken away except by a lawful judgment of his peers or by the law of the land. And that principle was applied in Australia in a case called Chung Ken Lim. And the holding in that case, or the ratio in that case, as they say in Australia, was that the common law of Australia knows of no executive warrant pursuant to which either a citizen or an alien can be deprived of his freedom by mere administrative action. So that was the starting point back in the 1990s, at least in Australia, with that decision. And as we know, that concept underwent a lot of change. The infamous case of Al-Khatib and Godwin made tremendous inroads into that principle. Justice McHugh actually thought that Al-Khatib overruled Chung Ken Lim, but in recent times, particularly a decision called Plaintiff S4, breathed life back into the principle in Chung Ken Lim, and was notable because the decision did not mention Al-Khatib at all, so it was damned by not just faint praise, but no praise whatsoever. Now, the case I wanted to talk about very briefly is Ruddock and Vidalis. So in late August 2001, a wooden boat started sinking off Christmas Island. It just so happened that a passing ship saw the boat sinking and went to their rescue, and that was the MV Tampa. The captain took about 400 asylum seekers on board and called for help because some of them were pregnant, some of them were injured and the like. But the government's response was to send about 40 SAS troops onto the boat, and there was a standoff at that point in time. So an application was made for a writ of habeas corpus to effectively release the asylum seekers from the detention on the boat. The Migration Act allowed the government to detain asylum seekers in certain circumstances, but it also allowed them to seek to have their asylum applications heard on the Australian mainland, to seek protection visas in effect. They weren't given that opportunity because they couldn't leave the boat, and arrangements were being made to ship them off to Nauru. So the application for the writ of habeas came before Justice North. He handed down his decision on September 11, so a fairly critical date there. And Justice North found that the writ should run on the basis that the detention was happening. There was actually a detention just by the mere presence of SAS troops on the boat, and that there was no basis under the executive power or prerogative power for a minister to order that detention. So it was, in effect, an illegal act, and the writ would run in that case. Now, that was obviously appealed, and it was a 2-1 decision. So the Chief Justice Black at that stage, he dissented, and his decision is very interesting. He looked at whether or not there was such a prerogative power in the executive to detain friendly aliens, and he found that the existence of the prerogative power was at best doubtful, and the last time it was ever used was in about 1771. But he didn't find it necessary to ultimately decide whether the prerogative power did extend to such a detention, because he found that the Migration Act was so comprehensive that it effectively excluded the possibility that there would be any prerogative power existing residually. So he would have dismissed the appeal. Justice French, with whom Justice Beaumont agreed, came to a completely different view. He found that there was a prerogative power, so he took a very broad view of what Section 61 of the Constitution entailed, and he thought that it was fundamental that the executive would have the power to determine who could come into the country and who could not. And that was his basis for finding the existence of the prerogative power, the executive power. And he distinguished that case of Chung Ken Lim on the basis that it was really looking at something else. It was looking at the validity of statutory provisions. He found that the Migration Act, although comprehensive in its terms, really involved grants of power and didn't seek to take power away. So therefore there was still room for the prerogative to operate. As a result, the appeal was overturned, and there was no writ of habeas corpus. And that's been heavily criticised, that decision of Justice French, especially by Professor Zines, because he found it difficult to accept that the framers of the Constitution would find an inherent coercive power, as in effect was, whereas it was denied or didn't exist with the imperial government. So that's a very interesting part of our history, and as I say, some life was breathed into it after the decision of Al-Kitab, but as I say, again, that decision I think is now in question because of the later jurisprudence in the High Court. With that, I happily hand over to Patrick.
Thanks, everyone. You can all breathe a sigh of relief. Mine don't delve into decisions in the way that Tom does. But in the late 1990s, I was a student at a German university, and I was there for quite a meaningful period of time, much to my Austrian mother's disgust of living in amongst the Prussians. But nevertheless, I made that deliberate choice, again to her shock and surprise. But and the time that I was there, I lived in a university town, and I lived in the middle of the town, and it was about a 3-kilometre walk to the university that we all did. And I did that walk each day, and as I did that walk, a great part of that walk on the footpath ran parallel and overlooked the train line that ran through the town. And one day in summer in 1999, at the age of 22, I was walking, as I was at most mornings, up to university, and I saw a freight train that was coming towards me, and we all know that freight trains, of course, continue on for quite a while, and when it did, I noticed that on that freight train was tank after tank after tank, white tank, military tank, with, of course, the unmistakable black letters of UN written on them. And I still remember that image very clearly, of course, because I said those freight trains just go on forever. And I continued my walk up to university, and I met then some of my friends there and asked them about this, what I'd seen, and if they knew anything about it, and where in particular these tanks were going. It's not something that you saw every day, in particular passing through Germany. And their response was, well, it being 1999, of course, that it was going to Kosovo. And they also told me the reason why these tanks were going to Kosovo. And at the end of the Second World War, there was restrictions placed on the German Home Defence Force in every facet of its own defence, and part of that included each year a certain amount of tanks that Germany was able to build for itself, for its defence forces. And every single year, Germany complied with that quota, and it didn't breach it. And that meant that when we came 40 years later to the Yugoslavian conflict, as it then was in the 1990s, of course, at that time, the German Defence Force had not left Germany since the Second World War, and it had not been called upon to defend her own borders. And so, in essence, over the last 40 years at that time, what had happened is that the German army had effectively been stockpiling tanks. It had complied with the quota each year, it hadn't breached it, and of course Germans build things to last. And so the tanks were effectively sitting there. And in 1997, the UN complained that they were running desperately low on tanks. And as part of that process, the German government said, well, we have one or two, use ours, use as many as you wish. And they did. And when they checked the ledger, as it were, they discovered, much to their surprise, that for the second time in history, Germany had the largest tank army in the world. And understandably, there was significant emotion from that, and within in particular the countries that immediately bordered Germany, not least our French friends, and also, but in particular, domestic concern. And the debate in Germany and how it was shaped and how I saw it happening as a student is one that most countries, I think, and are very lucky to have very little idea about and be able to understand what that debate was and how and the direction it was travelling, because, of course, of Germany's history. There was debate and there was discussion about the utility of having so many tanks and the spend and all that, but that wasn't the issue. That wasn't the issue. The issue was the very deep, sombre realisation by the German people that yet again they had been deprived of the right to hold consecutive governments to account, and that they had to find out this way. And the mood in Germany where they had not been able to hold their governments to account, and that this had been happening, it doesn't matter what the motive was, the entire time, with the backdrop of its history, stirred, as you can imagine, extraordinary emotions at the time. And that mood wasn't lost on me. At the age of 22, most was lost on me, but nevertheless that wasn't. And when I came back to Australia, apart from being a card-carrying member of the German Social Democratic Party, I also came back and still have a significant and perhaps overinflated hypervigilance and fear, I will say fear, of any government that tries to widen the gap, whether openly or covertly, between accountability between it and its citizens. So that effectively then brings me to part one, and don't worry, there's only two parts, so don't worry, of the presentation, which I have called Victory, or headed Victory at All Costs. It is the backdrop as it is, so I want to go over it in general terms. I'm not going to go into great deal of detail because part two is the main point of my discussion. And what always has continually surprised me is, despite the wonderful words that governments have and the great slogans and everything that they tell us about how absolutely extraordinary they are, and they must be because they tell us that, is that it's difficult to imagine any other relationship that is as suspicious and as sceptical as the relationship between a government and its citizens. But nevertheless, when I eventually came back to Australia in 25, I started as a graduate at Phillips Fox and in the employment team, and it had the job of prosecuting on behalf of the New South Wales Work Cover Authority, as the SafeWork New South Wales was then called. And so I was thrown into a job in private practice of prosecuting for the regulator. And that is all that I did for the first couple of years as a graduate. And like everyone else, we'd go down to in front of George Miller and we'd run the prosecutions, and we'd brief out if they were defended. And someone had the good sense to actually sit me down and say, look, you're going to be prosecuting, and there's a few things that you should know. Putting aside the fact that I did my degree in Newcastle, so the first question of my finished my degree in Newcastle, so the first question of my entire law career was, where's the Downing Centre? When I was told you have to go there this morning to run a plea. Thank God for David Shin, who actually then told me what to do. But nevertheless, someone within the firm actually said, because you're going to do this prosecuting thing, you have to be aware that there are a few things you have to do, and you have to know, and you have to be aware that these are immovable principles, and if you don't take them seriously, then you're not for us. Okay, sounds pretty serious. One, you have to be transparent. Now, coming into a private practice as a graduate lawyer course, not many people hear that word, but this was fundamental. This is fundamental about 16 years ago when someone sat me down for this conversation. Secondly, that if you're going to prosecute, all you're concerned about is putting your case to the judge. They're not your opponent. You're not against them. They sit there and put their case and you put your case, and that's what it's about. You're not against them, and you don't use the state's resources to be against them. And the third is that you have limitations. And if you find the limitations difficult, you're not going to be a particularly good prosecutor, and in fact you ought to embrace the limitations. And here they are. Here are the prosecutorial guidelines. Here's what you can't do. It was a long time as a prosecutor before someone told me what I could do. And I think that is a staggeringly healthy system, that you are told what you cannot do as a prosecutor, and that you must embrace that. And finally, that if you ran your case and the court was simply persuaded by the argument of the defendant, and so be it. you were not wedded to the case. You moved on then to the next one. And what that meant then is, apart from the fact that I had significant comfort that I drew as a younger person walking down the street thinking, oh, well, as I said, not much occurs to me, but I thought, well, if this applies to everyone else, then it's fair to say it applies to me. And that seems pretty good if I walk down the street, to not necessarily fear the consequences of doing that. But it also meant at that time we had a fantastic working relationship as prosecutors with counsel and those who were defending. Because you could ring them up, because you knew you could trust them, they could trust you. Now, that's all wonderful and that sounds good. Clearly there's going to be exceptions to that, and clearly people have different experiences. But I can only speak for mine, and that was about it, and that was it. And then about probably 10 or 12 years ago, I started to notice some changes. Now, I don't say that those changes happened 10 years ago. I say that is the first time that I began to notice them. There's two things. Many of those protections that I took for granted walking down the street, feeling very impressed that I knew these protections, I saw being chipped away at by successive governments, state and Commonwealth. And the other thing which surprised me even more was that by this stage I'd moved across to a defendant practice. I wasn't particularly a good prosecutor because I had sympathy for the defendants. By the end of it, was usually chiming in with George Miller when he'd say, oh, I think it's a Section 10, don't you, Mr. Barry? I think so, actually, Your Honour. But for God's sake, don't put it on the transcript. Nevertheless, so I was very content in a defendant practice and realised that my dealings with prosecutors, especially in that safety space, I saw what I felt to be an increased disregard for the prosecutions that were left. And I don't say that of all prosecutors, but nevertheless, that is what I felt at the time, and it's what I've increasingly felt. And since then, I'll admit that what it's brought about in me is mixed emotions that are ordinarily unwelcome. A lot of anger, because I have difficulty letting these things go, so I seem to be irritated more often than I'd like to be. Exhaustion, because this sort of behaviour, it wears you down. And you keep going and you keep going and you keep trying to push back, and you keep seeing a lot of these rights and privileges being removed and more strength being given to the prosecutorial machine. And it wears you down when you try and fight that. And disappointment. And I suppose that's the centrepiece of my unwelcome emotions, because disappointment that despite all this going on in the public eye to some degree, in fact, and I'll come to just how public it is, in fact it's almost seen to as a good thing in so many ways, we as a people don't seem to care. We don't seem to really care about it, and the great masses just sort of seem to, without sort of sounding too critical, but so long as you've sort of got a membership to a particular sporting club and you've got an enormous television and a purple or green ute, you're all right. We don't care about these sort of things. And that frightens me, and I cast my mind back to the debates that were happening in '99 as a student, and I'm reminded of those very different views. So I wanted to then just briefly set out there's a test now about what the government has now in place, that it relies on, as it were, when it considers to what extent it might curtail or abrogate some of the rights that we've got. That's at paragraph 12 of the paper. It's simply just a three-part test, and I'll read it briefly. There's a decision in Brown and Tasmania, 2017 decision. It's simply this, that first, does the law effectively burden freedom of communication about government or political matters, either in its terms, operation or effect? Second, is the purpose of the law legitimate in the sense that it is capable of the maintenance of the constitutionally prescribed system of representative and responsible government? And this is called the compatibility testing. And third, is the law reasonably appropriate and adapted to advance that legitimate purpose? If the answer to question 3 is no, then it doesn't get up. But in my paper, of course, it's not possible, and in this discussion it's not possible to talk about every encroachment on every act at every level. I don't seek to do that. I've kept it at the moment just confined to some Commonwealth encroachments, and the two areas, or what I've rather separated as two areas that I think are important protections that have been interfered with, and some of the jurisdictions that have suffered that interference. Those protections, there's only 3: the burden of proof, strict liability and absolute liability provisions, and one that is very, very close to my heart, which is the privilege against self-incrimination. And the two areas that I've picked is anti-terror legislation and my own practice area, which is work health and safety. But as I said, I'm only going to go very briefly and broadly over them, simply just to put it into some sort of backdrop. As to the burden of proof, of course, front and centre, it is always going to be anti-terrorism legislation. It has been for a while. And in particular, and again, I simply just note from my own, from the paper, again, very briefly, the criminal code, the Commonwealth Criminal Code, and the amendments that have been put into that, in particular section 102.6, which is about gaining funds from terrorist organisations and using those funds to some sort of degree. That burden has been shifted, and whereby the Law Council said that it was unclear why the defendant should bear the legal and not the evidential burden of this issue, observing that the jurisdiction for the departure is unclear in the case and may be unjustified. So if you're getting, all that's necessary effectively then is to simply just say, oh, well, this is what we take the view that this is what's happened. And the legal burden then is on you to deal with that, not the evidentiary burden. Of course, that's a very important, very, very important difference, and one that I think is staggeringly unfair when the legislature doesn't clarify why that must be so. It's one thing to shift an evidentiary burden, it's another thing to shift culpability and the legal burden to someone, especially in the light of terror legislation. But of course, this is the world we live in now, and this is what concerns me all the time, is that we live in a world now where politicians are extremely vocal about this issue, and they often start things by saying, I'm not going to apologise for making this country safe. Of course, we didn't ask you to apologise, we didn't ask you to actually explain why you should be sorry. But recently, even, for example, and you look at the wording, in 30th April 2018, this state's Attorney General said in relation to the criminal justice reforms, that of course we're all familiar with, and this is my favourite, these tough and smart reforms, it's like a script from Utopia, these tough and smart reforms encourage serious offenders, as opposed to your standard offender, to enter early, appropriate guilty pleas, as opposed to the inappropriate guilty pleas, enabling victims to get on with their lives and police to return to the front-line duties. That's where you do that gesture, by the way. And the good attorney then said that $93 million of our hard-earned tax dollar, he didn't say that bit, will accelerate the wheels of justice to help ease pressure on the district court's backlog of criminal cases. I would have thought more judges. What would I know? But $93 million so that offenders can enter early appropriate pleas. And this is going to ensure that extreme culpability, so not culpability, extreme culpability, that's in the Act, of course, now that's a very important phrase, extreme culpability, are adequately punished. Judges will have discretion to decline to apply any discount. Arguably always had that, but anyway, that's okay. And introducing this, when he introduced this in October last year, he called it the Safety First Justice Reforms. I love that, because if it's safety first, can't we just say it's safety first, everything else second? I mean, surely why can't we say that? That's what it means. If safety's first, either everything is 2, 3, 4 and 5 onwards, everything else, no matter what, or everything happens to be at second. But I think if you called the reforms safety first, everything else second, might not have been as popular as just safety first. And then we come back to these silly comments, well, I'm not going to apologise for making people safe. All right. And again, these emotive words that we see all the time, dropped now into the centre of government. The name Minister for Border Protection is more evocative of images of fear than the Minister for Defence. And yet the Minister for Border Protection has the role of fending off poorly built, wooden, hole-ridden, rickety boats that on occasion come into our territorial waters. And the Minister for Defence may one day be called upon to defend us from an approaching foreign fleet. But yet we use these words now, Minister of Border Protection, that sounds important, that sounds, we're being tough on that. And so it's very difficult then when you've got this rhetoric going on to stand up and say, well, I have concerns about these rights that are going on. I think that this is a problem. I think that this does touch upon, and we need to look at the scales, because of course, again in Australia, because I do not drive a green ute, and I do not have a large television, and I do not have a home built by Simmons, that the problem is, dare I say, and I'm perhaps being a bit facetious, but those people who stand up and do say that I have a difficulty with this, are somehow branded as some sort of minority bourgeoisie, and that seems to be increasing more and more. They say, people think like, oh, small minority have a difficulty with this. Well, that's becoming increasingly so. Small minorities seem to have, and that for some reason that can just be dispensed with and put aside. We have seen what happens when governments put the interests of small minorities aside. We see it all of the time. To let a government get away with that is extraordinary and breathtaking, and yet it seems to be increasing. Strict and absolute liability provisions, again, in my area of practice. Section 19, which is the principal duty, and each element of those offences strict liability. So it takes out the mental element. And people say, okay, well, we need safe workplaces. Well, of course we do. No one's saying otherwise. But the difficulty then with the provision is, we get the comfort of saying, oh yeah, but the burden's on the Crown. They have to prove that. Yeah, the difficulty is, though, is that when you make every single element strict liability, it means that you have a scenario where effectively the Crown need only allege certain things and is capable of sitting back and not discharging its function to the level that it ordinarily would have in any other, inverted commas, regular crime. That's one thing, but the other problem I have with this is that it means all the time that defendants are constantly put in a position where they're forced. Sorry. There you are, mate.
Sorry.
There you are. We're constantly forced to run a positive defence. And the section doesn't provide for that. All we need to do is, in the section, is simply argue under Section 19 that the Crown has failed to the requisite standard to prove that the defendant failed to take all reasonably practicable steps, like any other normal, as in inverted commas, normal criminal matter. But because of the way it's pleaded, you can't. You've got to sit there and run this positive defence. What we did do, and it's what I call the sleep at night submission, to give the judge comfort that if something else happens next week, that judge doesn't want to be on the transcript as letting someone through the keeper and being on the front page of the Daily Telegraph. But what shouldn't be about that? It shouldn't be about that. And yet the provisions simply have the function of doing that. And that's an important difference, and it's an unfair difference. But nevertheless, that's the position that the defendants are put in. And finally, the one that's very close to me is the privilege against self-incrimination. And for me, it's the most important. Again, in my jurisdiction, inspectors have extraordinary powers that the police only dream of. Powers to enter a site on a reasonable suspicion, power to seize certain documents subject only to really one real limitation, that's privilege, and a power to coerce people to answer questions, to force people to answer questions. And it doesn't matter whether you're like me and sort of naturally antagonistic and don't like that. That's beside the point. And again, that's what a lot of the inspectors say. Oh, Mr. Barry, you always want to pick a fight. Yeah, I do. That's my job, mate. That's my job. But no. This is just, don't worry. They've got to sit there. They've got to come and answer it. But they got the safety. They've got the protection of 172, which says we can't use it against them. So really, it's the same. Of course, well, it's the same. Well, why bother having it? It's clearly not the same. If the legislature's intention was to simply preserve the privilege against self-incrimination, then just preserve it. Why have a section that carves it out, but then in the next section is said to be the comfort section that says, oh, no, you'll be fine, don't worry about it. It's just absolute nonsense. And the reason why it's nonsense is a couple of reasons. One, and I've said this more times than I care to remember, so it doesn't bother me it's being filmed, inspectors abuse that power time and time again. And in particular, they abuse that power, which the fact that even happens in this country, the fact that even happens in a criminal jurisdiction should have people mortified. They get away with it constantly. Because what they do is they come up with these powers, they're big shiny badges, and there's a shinier than any other regulator. And they come up to people who are not represented. They say, you've got to talk to me. You have to speak to me. And of course, these people don't know, and they're frightened. Why wouldn't they be? They're just participants in the process. And they say, oh yeah, you've got to. But then what they don't issue the caution. The caution is then what enlivens the protection that they have. They sit there then for 6 hours and get all these answers out of them and turn around and say, oh, we've got voluntary compliance. And that means the protection doesn't apply. Now, arguably, then that material is inadmissible. But why should I be put in the position where I've got to have the argument? The limitations are there for a reason. It's not a game. It's a very, very serious process. But these people use it as a toy, constantly. And the second one is that it simply doesn't put into perspective who are these people in this process. It works for large companies. It works for large companies with a big board and big management where they can roll the worker out and ultimately then the protection for the individuals is preserved. But the great majority of prosecutions, 2/3 of my practice, are small and medium-sized companies that are put through this process and are prosecuted. And what does that fail then to recognise? that most of these companies are mum and dad companies. That the only people who are forced and can be forced to actually speak and answer for questions for the company are the mum and dad that run it. They're the company's them. And so, okay, fine. They call them in, they drag them in, give them the caution, and they start answering questions. Great, mum and dad are protected. But then when they go and prosecute the company, which they can, it cannot be divorced from mum and dad because the company's in their lounge room, the company's in their kitchen, the company pays the school fees. They're the company. And so, in effect, they're potentially, usually just dragged, as it were, through the process. They cannot divorce themselves from that company. And so time and time again, families are ruined through this process because they've had to answer questions and they've been forced to answer questions that in any other system they wouldn't. And you could lawfully frustrate the regulator in acting for those people. This time you just got to sit there and say, well, I'm sorry, but you've got to do it. And that can't have been the intention of Parliament. That cannot have been the intention of Parliament to do that to a great many defendants. And if it was, then it's perverse. It cannot be so. So anyway, that's part one and of what I see as some of the worrying things that's happening. It's happening in this state, it's happening in every other state, it's happening at Commonwealth level. And it is simply, it's not even the tip of the iceberg. It's just a small slither of which there is a great many more of those examples. With that backdrop then, I move to part two, which is in relation to ministerial oversight. We know what ministerial oversight is, but it is vital for two reasons, because it does two things at the same time, which I appreciate for a minister is extraordinary, but nevertheless it does it. And the first thing is this: it ensures that the functions of a regulator relying on the enforcement of a certain act are overseen by the minister committed to that act. That's fundamental. But at the same time, it also means that that minister must report to Parliament, and therefore, in essence, to us, on the exercise of those powers under that act by that regulator. And that is the connection, as it were, one way, another, and the other way at the same time, to the regulator and to the people through the minister. And it's how we hold Parliament to account. It's how we hold the ministers to account. And I always thought that this doctrine was untouchable. I can point to about 8 or 9 things throughout the course of my time at university that I remember and was interested in, and weirdly enough, this topic I was. And it provided me with some sort of security blanket, as it were. But over the last 3 years, yes, I'm that exciting, that's what I talk about on Friday night, but anyway, over the last 3 years, in a matter that I've been briefed in, I have learnt that particular states' indifference, the type of indifference that I referred to earlier about one of the two things that I've become increasingly worried about, even extends to this doctrine. And it's because of this. In August of 2013, a man by the name of Mr. Bashir operated a hotel on North Terrace in Adelaide, and he still does. And this hotel, like any other good hotel, engaged a pest control company to come and lay rodent traps in its cellar. And in August 2013, one of the pest control workers, a Mr. Barry, no relation, went to the hotel, and in the course of laying his rat traps, he fell through the opening down to the basement. So he fell through and down a flight of stairs and hurt himself. Over the next 18 months then, SafeWork South Australia, operating under an act, of course, it is by and large, for the purpose of this discussion, a twin to ours here in New South Wales, investigated the matter. And they, of course, relied on powers and used their powers. So they're a very active regulator, and they used their powers. And what did they do? They entered the workplace, they entered the hotel. They took documents off Mr. Bashir and off his workers. They issued Mr. Bashir with improvement notices and prohibition notices, forced him to do things, forced him to stop doing things, interfered with his business. And they coerced Mr. Bashir to sit down with them for many, many hours, and all his workers, and to answer many, many questions, all of which he had to do. There's a protection that exists in South Australia that doesn't exist here, but in any event, he was forced to go through that process. And in May of 2015, then the regulator brought proceedings, single charge under Section 32 of the Act, alleging a failure under Section 19. I was briefed. It was going to be a very simple plea, and I looked at the material, and it was definitely going to be a very simple plea. And I was set down for that plea in December of 2015. And then in November of 2015, we received a letter from the Crown. And it was a letter that said, look, because we're a model litigant, that always worries me when they start sentences like that, we've got to tell you something, increasingly worried, but don't worry, because it's not a problem. Okay, it's great. I'll put it down then and bat on. But anyway, I decided, despite the fact that it wasn't a problem, that I'd read the letter. And this is what effectively it said, is that on the 20th of December 2012, Parliament had committed the Work Health and Safety Act to the Minister for Industrial Relations. This is in the good state of South Australia. And on 1 January 2013, the Work Health and Safety Act came into force. So far, all good. SafeWork, which is a department, was designated under the Public Service Act to the Attorney General's Department. And the management then of SafeWork South Australia, understandably, was to be and is through the Attorney General. See what's going to happen here? The Minister who was meant to be committed to the Work Health and Safety Act was the Attorney General, not the Minister for Industrial Relations. Now, I would have thought, and I'm not Poirot, but I would have thought that when wondering what department the regulator's in, it being the Department of the Attorney General, there's two words that give away what minister ought to be committed to the Work Health and Safety Act. But nevertheless, the Minister for Industrial Relations was committed to that act, and when Parliament realised this error, it committed the Work Health and Safety Act to the Attorney General on the 9th of September 2015. And it told us this in the letter. And under Section 152 of the Work Health and Safety Act, the regulator is to report to the Minister on various things in relation to the operation of the Act. Not in relation to the operation of the department and how much stationery they order and who they fire and who they hire. On the operation of the Act, which gives rise to their powers. And of course that must include the bringing of prosecutions, it being the most solemn power that they have. But for 2 years and 9 months, the Minister responsible for the Work Health and Safety Act, Minister for Industrial Relations, was incapable of exercising any oversight at any direction, whether it be to the regulator or to Parliament, over the Act, because the regulator during that time was reporting to the wrong minister. The regulator thought that it was to report to the Attorney General, and that was the regulator's evidence. And because they thought that the Act had been committed to the Attorney General, evidently so too had the Attorney General. But this meant that the prosecution was brought without the correct minister knowing that it had been brought, and therefore the correct minister being incapable of accounting to Parliament for the bringing of that prosecution. And the question then is, was the bringing of that prosecution invalid? Pardon me. We say it is. And we say it is because Section 4 of the WHS, the Work Health and Safety Act, is the definition section, and it doesn't define minister. It defines department, of course, the regulator. And it says that it is the department. I'll read it because it's only one provision to read that makes sense. Section 4 says that the department means the administrative unit of the public service that is under the minister, responsible for the administration of this Act. The administration of this Act. And so when you look then at, all right, well, who's the minister responsible for the administration of this Act? The Acts Interpretation Act in South Australia makes it clear that that minister is defined as a minister who is committed to the administration of an Act. That is the definition under the Acts Interpretation Act. That definition, and again, I will read it because it's the only thing I need to do to need that context. The Acts Interpretation Act definition for minister is when used in an Act, the Work Health and Safety Act, the Minister of the Crown to whom the administration of the Act has been committed by the Governor or in whom the administration of the Act is otherwise vested. That is the Acts Interpretation Act, and we say is the section that applies, and therefore it must be the Minister for Industrial Relations, that it cannot be the Minister, it cannot be the Attorney General. And of course, therefore, the only Minister at the time capable during that 2 years and 9 months, capable of exercising any responsibility over the WHS Act was the Minister for Industrial Relations, in line with the definition under the Acts Interpretation Act. But of course he couldn't. The Crown then relies on the Public Service Act in South Australia. It says that Section 28 is relevant. And I might add, the Public Service Act doesn't have a definition of minister. For some reason, that I was told by the Crown that was irrelevant. But anyway, it's Section 28 is the minister responsible for an administrative unit. Of course, the regulator is an administrative unit. And it relies on the wording, can't be said to be a definition. The governor may, by proclamation, designate, not commit, designate the minister who will be an administrative unit's minister with responsibility for that unit. And their argument is effectively, the department's here under the Attorney General's department, and the department's been designated to the Attorney General under Section 28 of the Public Sector Act. And what does the department do? It enforces the Work Health and Safety Act. So, the Attorney General had control over the department, as it were. So the only control that it's going to exercise over the department is clearly, apart from the stationary order, going to be prosecuting, Your Honour. Because that's what they do. That's the thing that they do. So same. It's okay. And of course, the difficulty that we have with that, first, is that the Public Sector Act talks about the designation of a minister to a department. Here we're talking about the committing of a minister to an act. They're two different things. At its highest, the Public Sector Act gives the Attorney General some sort of power or direction over the department in relation to employment matters. And in fact, the Act very dutifully sets out those employment matters to which the Attorney General may direct the department. It's very clear. But not the administration of an act. It doesn't say that. That was under the control of the Minister for Industrial Relations. And next we come to my favourite. It's always been my favourite because it seems to be nothing better than when someone thinks, this is a get out of jail free card for anything, as it were, Project Blue Sky. The Crown has stood up and said, no. Also, despite the fact that that's all okay, we also rely on Project Blue Sky. And then you sort of say, how? Because this was that wasn't Parliament's intention. I'm quite sure it wasn't Parliament's intention to get it wrong. I don't think anyone is suggesting that it was otherwise. But the thing that has been my constant irritation with people's view on Project Blue Sky is that it is not authority for parliamentary intention. It is authority for statutory construction or legislative purpose. That is what the test for Project Blue Sky is at the time, not parliamentary intention. Otherwise, Parliament could simply just all the time say, that was our intention and didn't quite come out that way, but there you go. And when you look then in particular, and when you read Project Blue Sky, there's two decisions. The Chief gave a great test for invalidity, and he took the short road, and it's a good test, and the plurality then got to the same point. They were a bit more. But crucially, all they say is this, and it should go without saying, but at paragraph 91 of the decision, it says that this is in the plurality's decision, an act done in breach of a condition regulating the exercise of a statutory power is not necessarily invalid and of no effect. Whether it is depends upon whether there can be discerned a legislative purpose to invalidate any act that fails to comply with the condition. The existence of the purpose is ascertained by reference to the language of the statute, its subject matter and its objects, and the consequences for the parties of holding void every act done in breach of the condition. Nothing in the Act, nothing in the Work Health and Safety Act evinces any sort of purpose or act to invalidate any action that would fail to comply with the bringing of prosecutions under the Work Health and Safety Act. There is nothing there that suggests that this is the way you bring a prosecution, this is the way you report it to the Minister, but if you don't get that right, don't worry, it's still good. Nothing says that. Nevertheless, the difficulty I've always got then is that clearly, when you read that, and clearly when you look at that, it was clearly Parliament's intention. It can only be that the Act have proper oversight, that the bringing of prosecutions have proper oversight. Of course that's the case. Otherwise, why commit the Minister? Why commit a Minister to have oversight of the Act in the first place? And when you realise that you've committed the wrong minister to the act, why then commit the right minister to the act afterwards if it doesn't mean anything? If it's all near enough as good enough under the Public Sector Act, why do that? And finally, the Crown has also argued that if our argument was to be accepted, that it'd be frustrated. The outcome would be frustrated. A bit hard to frustrate something that's invalid, but nevertheless, the problem I have with that argument is that it's conclusionary. You can't start an argument by saying, well, here's the difficulty I'm going to end up in, so I'm going to engineer my way back to the start of the argument. Start with the words of the statute. What do they say? When you look at the words of the statute, and when you look particularly at the Chief's test under Project Blue Sky, we say at least that we meet the test for invalidity of the charge. The difficulty I've had with this whole matter for 3 years is that I can't help wondering if it was the same circumstances, but the parties were just the participants. What would happen if the participants were just a little bit different? For example, and this is simply for the sake of argument, that the police force was a department designated to the Minister for Police. And let's assume that on the running of the police force, the Commissioner reported to the Minister for Police. And let's also say that the Police Powers Act, governing everything that the police do by way of enforcing every action that they do, was accidentally committed to the Minister for Fisheries. But the Commissioner didn't know that the Police Powers Act was committed to the Minister for Fisheries, so the Commissioner continued for a period of 2 years and 9 months to report to the Minister for Police on the enforcement of the Police Powers Act. And for 2 years and 9 months, the Minister for Police answered for the enforcement of the Police Powers Act to Parliament, in circumstances where he was not capable of doing so because he wasn't committed to the Police Powers Act. And for 2 years and 9 months, there was a disconnect between the correct minister overseeing the enforcement of the police powers under the Police Powers Act, and at the same time, there was a disconnect between the correct minister answering for the enforcement of police powers under the Police Powers Act to Parliament and to the people. What do you think would happen? There'd be rioting in the streets. There'd be absolute rioting in the streets if someone had suggested that for 2 years and 9 months that police were not checked, that their actions were not supervised, that we couldn't keep them in check. Absolute rioting in the street. But because it's just a little safety regulator, as it were, and the state advocate in South Australia who referred to it as quasi-crime, I don't really know what that means. I mean, if it's crime, it's far more crime, as it were, than what the coppers have got, because most inspectors in the Work Health Safety Act have 3 times the powers of what any copper's got. But apparently it's not 3 times as serious. So anyway, in August 2016, I then ran the argument, first instance, and went down in flames. Absolutely went down in flames. In a way I thought I might. What is disappointing, though, is Industrial Magistrate Ardley, that heard the matter in his decision, which is 25 January of 2017, gave a 14-page decision, and sadly, up till page 13, in the first paragraph, it simply just regales the reader with what I said and then what my learned friend said. And the one paragraph that says His Honour's reasons is simply, I'm of the view that the definition of department introduced into the predecessor legislation, namely the old Health and Safety Act, in exactly the same terms as appears in the WHS Act at the time that the Public Sector Act was enacted, leads to the conclusion that the construction of the word minister is that of the minister proclaimed under Section 28 of the Public Sector Act, and the minister responsible for an administrative unit. That's it. It's 2 years of preparation, and I got a paragraph. And you know that's not acceptable. Both parties, including the Crown Advocate, provided very meaningful arguments to His Honour. This is a serious issue. It's important. And it is unfortunate that all we got was a paragraph. Nevertheless, we then appealed, went to a single judge of the South Australian Employment Court. They got it, and the particular judge got it and immediately referred it to the full court of the Employment Court, and they got it and decided that the matter was right for referral to the full court or the Supreme Court, and it's that has just been done. Well, that was done last year. And again, just to finish up the questions now, we're on next September, in a month's time, 3 weeks' time actually, in front of the full court of the Supreme Court, the highest court in that state. They're not having a court of appeal. The questions that are in front of the full court, Supreme Court of South Australia, are simply: does the words "the Minister" found in the definition of department in Section 4 of the Work Health and Safety Act mean either the Minister is defined in Section 4 of the Act's Interpretation Act, such that the relevant Minister, for the purposes of the definition of department, was, at the time the information was laid, the Minister for Industrial Relations? Or does it mean the Minister, as designated pursuant to Section 28 of the Public Sector Act, such that the relevant Minister, for the purposes of the definition of department, was at the time that the charge was laid, the Attorney-General? Question 2, at the time the information was laid, the Minister for the purposes of the definition of department was the Attorney-General, but the administration of the Work Health and Safety Act was committed to the Minister for Industrial Relations under the Administrative Arrangements Act. Was the information valid or invalid? Question 3, was the regulator under a duty to inform the Minister before laying the information against the appellant that the regulator intended to lay the information against the appellant? And finally, the last question, if the answer to question 3 is yes, and the regulator did not inform the Minister before laying the information against the appellant that the regulator intended to lay the information against the appellant, then is the information valid or invalid? And I'll let you know how it goes. Thanks very much.